Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. I'm your host, Uncivil Law, and we are here with some continuing Murdaugh coverage, at least for the moment, to see if there's any reason to continue doing this stream. I figured we'd at least try to give it a go this morning and see what's going on. So let's see what's going on. This trial has been very uninteresting legally. The state's case has blown. I have hated it. Nothing interesting is happening except for clock, chandelier, and seal, which is by far and away the most interesting thing happening in this trial. I wish more was going on, and it's where the case of things. So we'll cover this for at least a little while and see what's happening. No guarantees this stream will continue. So, because I found the state's case incredibly boring. How do you make a double murder trial boring? That's the only real question at this point. How do you make a double murder trial case boring? The answer apparently is by calling witness after witness and going into mind-numbing, laborious detail that doesn't seem to have any connection to anything, and certainly not connecting any of the dots. And then finally culminating by calling a fingerprint expert to testify to the fingerprints we didn't find. That's really where I lost all hope in this case, and all the things going on in this case. So, yeah, we'll see what's going on. The fingerprint expert testifying to the non-fingerprints is where I lost my shit. My mom said that she caught that part of the stream and laughed at my despair because of how horrible it was. And it's like, yep, that's kind of the way things are going over here in South Carolina. Not so great. Is it a Twitter link? I don't have a Twitter link. Well, it'll populate eventually. I don't think the Twitter link exists yet because I just created the stream. But when the Twitter link exists, I will create one. But 73 of you found me anyway, so that's nice. Yeah, the Twitter link doesn't exist yet. It should automatically populate in about 10 minutes or so, and we'll go from there. There was serious false advertising with this trial. Just can't make it any better. I feel you, Haley. I feel you. I don't think the case is boring, really. You think this case is interesting? You and I must be watching different trials or something. The fingerprint expert really was the cherry on my parfait. That's where I really lost my shit. That was the moment that broke Uncivil Law. I feel like, I'm a patient man. I'm a patient man. I'm a kind man. But everyone has his limits, and we found mine. And apparently my limits were found late last week with fingerprint expert testifying to the fingerprints we didn't find. Kathy, in answer to your question about doing recaps, it's an interesting idea, but the problem is, how do I do a recap without actually watching the trial? That's the problem. How do I do a recap without watching the thing I'm recapping on? So either way, I'm watching the entire trial. I suppose I could have the trial on in the background, or just the audio in the background, and just be listening to it. But one way or another, there's no way for me to recap the thing without me watching or listening or consuming the thing. So I don't really understand how that would work in principle. Also, Carrie Bear also raises a very interesting question of how do you recap this mess? Because what am I supposed to say in recap? Well, in today's trial, we heard from state's experts who decided to go through. Today, we heard from Walking Spreadsheet, who decided to tell us every single time the phone turned on, turned off, received a message, vibrated, the orientation changed. It was also very important for us to know exactly how long it took to change the orientation and for how long the orientation was changed. And did you know that in column Q on line 34 at 8:56, 8:41, and 53 milliseconds that the phone changed and vibrated for exactly 1/8 of a second, and then stopped vibrating again? Did you know that? Would you like to know more about Would you like to know more about this phone in its painstaking, laborious detail? You know, walking spreadsheet was yeah. This is Seal clock, chandelier, chicken conspiracy has been the best. I tend to agree, for sure. Hey, 100 of you managed to find this thing without a Twitter link of any variety. Also, I didn't create a thumbnail this morning. Hey, there's the Twitters. You can share this Twitters if you like. You're sharing the Twitters. In no way prevents me from ending the stream and preventing the whole thing never happened. But if you want to share it for as long as the stream exists, then you can be like, I was there on Uncivil Lost. Like there's no record of such a stream. It never happened. No, he deleted it. He memory hold it. And be like, no, memory hole it. He would never do such a thing. Who do you think he is? Eliza Blue? Yeah. Okay. This is why I watch you. I'm the best. Yes. I do like. Oh, shit. Ah!
Please be seated.
I'm awake. I'm awake.
Good morning. You ready to proceed? All right, may proceed.
I believe we're again here in camera matters, and the state would call Mark Tinsley to the stand.
Raise your right hand, left hand on the Bible. Do you affirm the testimony about to give the court in this trial shall be the truth? So help you God.
I do.
Take a seat on the witness stand. State your name again for the records. Spell your last name.
Morning, Your Honor. My name is Mark Tinsley.
How you doing, Mark? Is your morning going better than mine?
Mr. Tinsley, how you doing today?
Good.
Very quickly, you understand, obviously you're a lawyer, you understand we're here for some in-camera proceedings, so we're not going to go into every bit of background and detail.
Oh, God, thanks.
Before you testifying before the jury. You understand that?
I was really looking
I do want
forward
to
to
kind of
hearing
move
about
through
the history of
quickly
every
some of the
leaf
subject
on the
matter
Moselle
state,
property. I was
proposes
looking
to,
forward to hearing about them all individually and their entire history of changing colors and when exactly they fell off the tree.
I practice law in Allendale. I have a fairly statewide practice, primarily personal injury, plaintiff's work.
All right, and
Mr. Murdaugh certainly has on a nice shirt. I bet it's made of cotton. I'd like to know the history behind every single thread of cotton that's in his shirt, including exactly which piece of cotton it came from and its entire life cycle, and who picked it in its entire processing in every single way.
primarily focused in the 14th Circuit, is that fair?
14th and the 1st.
Yeah, the first. Okay. Do you know the defendant, Alec Murdaugh?
I do.
And how did you get to know him?
He practiced law in the adjoining county. I had a number of cases with his firm, small bars in the two counties, and known him since shortly after I came down there.
And do you know other lawyers in the what used to be known as PMPED firm?
All of them.
And are those individuals that you may have had cases with, or just generally in the same line of work with over the years?
Yes.
I want to take you to February 19, and are you familiar with the boat case?
Unfortunately.
The boat case, the much ballyhooed boat case.
Beach family
Are we sure that this trial is not about the boat case at this point? Because
Ultimately,
I thought it was about the
accepting
murders.
that representation,
That was my
the
understanding
policies,
of what this
number of
case was
defendants,
about.
including
I thought it was about the murders. We were going to learn about the murders and the murdering, but I'm learning about the boat case. I'm learning about chicken. I am learning
My
about
recollection is that I sued.
orientation changes of phone.
I know I sued Luther's.
Can phone really choose to change its orientation? Is that a choice
Which was
that
where
phone can make, change its orientation?
I sued the Murdaugh Family Trust,
Yeah.
which owned the property where the boat was launched from, and we believe that there could have been some drinking that went on there. I'm not 100% certain in the
Drinking on my boating? It's more likely than you think.
Alex's son.
We did learn about the Navy SEALs and the sunflowers. That is a very fair point.
And maybe Randolph Murdaugh personally as well.
Not long after you started the boat case, and well, let me ask you this. Did your client, Renee Beach, have any particular experience at the scene that informed how you were handling this particular case as you went forward?
She certainly had an experience that prompted the call to me.
And can you explain that to the court, please?
She wanted to go down to the bridge where the boat crash had occurred. I think this was either Monday or Tuesday, so the crash happens early Sunday morning. The scene's cordoned off, and she's told she can't go down there. And just a few minutes later, Alex's father and his wife pull up in a car, and they're waved under the tape, and they go down to the bridge. And she was very upset by that.
Okay. And did she, in your discussions with her, did she give you any particular instructions about proceeding forward in this particular case as part and based on that experience?
No. Nobody really gives me instructions.
I understand. All right.
Nick sent me a link, so I might bail on this stream and join Nick's stream.
Any chance to review and look at any insurance coverages that may be available to the defendant?
Court volume is very low. It was blowing out in my ear.
recollection is within the week, certainly 2-week kind of time frame.
But let me turn it up a little bit. I'll just turn down my
Who
volume
was
manually and turn up the
handling
court more.
The boat crash, as Alex's personal lawyer, brought me all of Alex's insurance policies, and so I reviewed them at that time, before I filed the lawsuit.
And what was the purpose of you reviewing those policies?
You know, in a civil case, the only thing that we can do to try to, under the law, make a party whole is recover money damages. And oftentimes, when we are drafting lawsuits, we will try to draft the initial lawsuit to make sure that there's insurance coverage. So
Can't really
that was
watch
the reason I
Nick's
wanted to-
stream here the way I'm
coverage.
setting this up. I can't really do
And
that.
beyond that,
Well,
sometimes,
I
like
can't really
did
do
with
that.
some of the initial defendants, you can, because of the circumstances, because of the culpability, how bad the liability is, how catastrophic the loss is, many times insurance companies can be leveraged to pay their insurance out, to get these people closure. No amount of money is going to make them whole. So the best that we can do is try to get them some closure and help them heal.
All right, and when did you determine, as you looked at what coverages were available to Alec that potentially could be relevant to the boat crash?
Well, so there was $500,000 that Progressive had on the boat. It was a watercraft policy. Although I've never seen the policy, that insurance was offered almost immediately to all of the victims, not just the Beach family. There were 2 other girls on the boat and 2 other boys, and including Paul Murdaugh. And so when I reviewed the policies, it was apparent to me that there was no possibility that any of the insurance that he had at the time of the boat crash would apply to this. And if there was a possibility, it would be limited to an idea that Alec was negligent in allowing Buster to give Paul his duplicate ID that he had made so Paul could purchase alcohol.
Did Alec have a policy, an umbrella policy with Nautilus at this point in time that was available?
He did not. He had.
And explain that to the court, why that was not available, please.
It appeared from review of the records that there was an open claim when the policy came up for renewal, and that open claim
Are we now in the
was a
middle of
Satterfield
the
matter.
civil
And that
vote
it
case?
was Nautilus and I think Lloyd's of London, and they would not.
As we're
renew
talking
the
about
policy.
insurance policies and
so he
umbrella
had to
policies
then
and what
seek
they
other
will or will
coverage,
not cover?
And what he ended up. Was
Why are
with
we in the middle of
Philadelphia,
trying to adjudicate the
and it was a
vote case?
commercial hunting operation policy that contained very broad watercraft exclusions. So they even barred a negligent entrustment claim as it related to a watercraft.
And that Philadelphia policy depended on Moselle being considered as a commercial hunting lodge, is that correct?
Not only Moselle, but the occurrence, in other words, whatever it is that causes there to be coverage, had to arise out of a commercial operation, as I read the policy.
Realizing that as it related to Alec, specifically, was he essentially underinsured as it related to what the recovery you were seeking in this particular case?
Oh, absolutely.
Right. And what was your ultimate goal, though, in seeking recovery as it related to Alec in this case?
Well, it changed over time. And I mean, initially, I believed that the case would settle. I didn't see how people could ignore the significance of the loss, the public support of the community for the Beach family, and then the hue and cry as it related to the liability and the Murdaughs in particular. And so, you know, it changes over time, but the one consistency was to get the case resolved.
Okay. And did you make it clear to Alec's attorneys that you were seeking a personal recovery that he would have to pay as opposed to just accessing what insurance coverage was available?
Always.
And that was consistent all the way through, is that correct?
All the way through.
Were you making substantial demands to
I
the
noticed
defense?
golf
that Alec
lawyer
made
is wearing all white
substantial
today.
recovery, personally?
I think by most standards, and I don't want to seem crass when I say this, but the Beach family stood on the causeway for 8 days while their daughter's body was in the water. I don't know that there's any amount of money that somebody would willingly take to go through what they've gone through. But if you were asking a lawyer who does civil work, was I making a substantial demand in terms of a settlement? I think that most people would say yes.
In your assessment,
Thank you,
did that
Kenneth. You're
come
very
as a
generous
bit
with
of
the chat.
a...
Very nice
or
of you.
did
Thank
the
you, Quinn.
defense express to you
Appreciate your support.
surprise that you were seeking a personal recovery from Alec rather than just simply trying to access what insurance coverage he had?
Yeah, some people did. John Tiller was primarily handling the case for Alec, and I didn't get that from John, but I got it from a lot of people.
In August of 2019, is there a particular conference that those in your line of work go to?
It used to be called the Trial Lawyers Conference, but yeah, it's in Hilton Head, and I went in 2019 of August.
Did you see the defendant there?
I did.
And did you have a conversation with him about the boat case?
I did.
All right, can you relate that conversation to the court, please?
Yeah, I think, I'm not 100% certain that it was a fundraiser either for Mr. Harpootlian or it was a fundraiser for Lindsey Graham. As you come into the hotel, there's a gathering area. It's in the evening before everyone goes to dinner, or it's immediately after. I'm not 100% certain. But the room's full of lawyers, and Alec sees me, and he comes across, and he gets up close in my face and says, "Hey, Bo, what's this I'm hearing about what you're saying? I thought we were friends." And I replied, Alec, we are friends. If you don't think I can burn your house down and that I'm not doing everything and I'm not going to do everything, you're wrong. You need to settle this case.
Okay. And so what was the point of that conversation? What was, if you can explain to the court what y'all were talking about? What is
But I'm going to burn your
to
house down.
as you understood it?
That he was going to have to pay was
That's
what
an
he was
interesting
hearing. That's
proposition,
what
I
it was.
guess.
That's what the point of it was.
I mean, we're friends, but I'm also a
I
lawyer.
took it as he tried to
I'm
intimidate
gonna
me. He
burn your
didn't
house
intimidate
down?
me, and sort of bully me into backing off.
Okay.
Was
I
there
can't
a,
say that I've ever had that particular conversation
mediation
with someone.
in
So
September of 2019?
There was, no, 20, September of 20.
20. Before we get there, we move into early March of 2020, and we probably all know the answer to this, but what happened in March of 2020 that kind of changed the world?
COVID, court shut down.
And did that have an effect on slowing down things in the court systems?
It definitely stopped the court system. We continued to take some depositions, primarily law enforcement. It was at the scene early on, and then ultimately, when everything finally shut down, I'm not sure if it's May or April, when then we were sort of confined to our offices.
Did you, during the course of COVID, take the opportunity to sort of present the case to a mock jury to get an idea of how that jury might respond?
I did.
And were the results very favorable for your client and not favorable for Alec?
They were.
Okay. Did you ultimately communicate that fact to the defense?
I did.
Had you come into possession of some social media videos that you believe would be very advantageous to proving your case and achieving a large recovery?
I did. And I shared those with John Tiller.
Let me get something marked real quick. Hold on.
he didn't threaten Alex and his property. He wasn't being literal. He was just saying, I'm going to go represent my client, and what happens, happens.
We'll show you what's been marked as Exhibit 401, State's Exhibit 401, and see if you recognize that document.
I did. I do.
All right, and what is that document?
It's a screenshot of text messages between myself and Tabor Vox. Tabor is assisting me in the boat crash case.
All right. Could you turn the screen to me real quick, please? All right, there's a reference here at the top. They damn sure aren't a placeholder or venue defendant, but they were hoping so. And then you respond about not walking, just taking $500K and not walking away from someone who's judgment proof. Is that correct?
That's right.
And I'm sure the court is aware, but just very quickly, what's being said there about Alec not being just a placeholder or venue defendant?
Well, so there are a couple of things going on here. In October of 20, I filed a motion to compel. Alec said he was broke. He doesn't have any money. He may be able to cobble together some amount of money, but he's broke. And I didn't believe it. So I filed a motion to compel, and about a week after I'd filed that motion to compel, Danny Henderson, who again was Alec's personal lawyer, came to my partner, said he couldn't believe that we were going after Alec personally. It was a line in the sand that I'd crossed, a number of things like that. So that's what this conversation is about. And by November, this is, I think, November of 2020, the Beach family, they want accountability. They want a pound of flesh, and whatever that's going to be, it's only going to be through a jury or through a substantial settlement.
All right, well, let me back up and we'll get to the motion to compel in a second. You mentioned that you had been told by the defense essentially that Alec had no money, correct?
He's broke.
Right, did they say he could cobble together a certain amount?
Thought he could cobble together $1 million.
$1 million. And did you believe that that was accurate?
It couldn't been.
All right, and why did you not
He
believe
can.
that
He's
was
broke,
accurate?
but he can cobble together $1 million. Guys, I am broke, and I
When you
cannot
practice law,
cobble together $1 million.
not
I'm just
necessarily
telling you.
with,
Okay.
meaning in the same
So
case.
we have
but
Alex
when you go to a
Murdaugh and I
roster
have
meeting,
different definitions of
If
broke.
there were 50 cases on the roster in Hampton, Alec may have had 50 or 60 of those
But,
those cases. And so they're actively being.
If everyone in chat
I know
donates
that he's
$5,000,
actively
I
making
could have $1
money, and
million.
you just can't
So
possibly be.
please donate
broke
$5,000 to the
if
uncivil
you're
law
making money,
cobbling
not the way
together
he's
$1 million
making money.
fund.
And then beyond that, I mean, my clients have known Alec and his family forever, and so their perspective is that there's generational wealth as well.
Did you, was $1 million going to be enough money from your client's perspective to settle this case?
It wasn't enough from my perspective.
Okay.
I can explain that if you want.
Yes, please.
Not to put too fine a
So,
point on it, but it's your
one of the
client
things that I
wishes
didn't
that-
appreciate, that I
dictate.
came to appreciate by this point in time is that, and it may not make a whole lot of sense, but if I told a lawyer who does what I do that I'd settled the case, there's a lot of speculation because I've had cases with the firm and members of the firm are my friends, that somehow there's a fix on. I think for a long time, Alec thought there was a fix on, that he was just a placeholder, a venue defendant.
Right.
And so if I told you I've settled the case, and then the next question would be, what did you settle it for? I said, well, I took the insurance company. If you knew what I know and what plaintiff's lawyers know, you'd think, well, there was a fix. The only reason I would take it is because there was a fix. I didn't see a substantial difference between that number and $1 million. And so I thought that if you told
You didn't see a substantial
10
difference between
lawyers who are
500,000
knowledgeable
and
about
$1
these
million?
kinds of matters, I took $1 million from Alec, who, from
Okay.
everyone's perspective, has lots of money.
Raise your
making
hand in the
piles of
chat
money.
if you
They
personally
would think that it was a
think
fix.
there's
So-
a difference between
so
500,000 and $1 million.
before we even get to what's a fair amount, what should you take? You know, the analogy I use with my clients is, it's kind of like that show Deal or No Deal. You may have the $1 million suitcase, or you may have a zero suitcase. But it's not until there's a significant enough offer that you could do worse that you should settle a case, any case. And so at $1 million, it just wasn't, there wasn't any risk to them that would prompt me to recommend them to take it.
Did you make any sort of formal or informal offer to them that involved the real property as well as any sort of payment plan?
When I was told that Alec was broke, I offered him a payment plan. Sometimes when you settle cases, medical malpractice cases, for instance, with the JUA, they will make payments. I offered for him to sign over Moselle and the beach house, open his books to see that he was broke, and then work out a payment plan on the balance.
So when you say, show me the books to prove that, what was your response from Alec's defense?
Well, it was sort of stonewalling to begin with. I mean, ultimately, I got a formal response, which was an objection that prompted the motion to compel in October of 2020.
Let me get this marked real quick.
He's stalling it, wanting to pay you millions and millions of dollars? Whoa. Amazing.
I'll show you what's been marked as States 402. See if you recognize this document.
Yeah. So this is my motion to compel, which attaches Alec's responses to the interrogatories and request for production.
All right. And when was this filed?
October 16th, 2020.
All right.
You see goth prosecutor all dressed in white back there? I wonder if she's feeling like we've criticized her. I liked the way she was looking before, but she's definitely chosen a different look today.
All right, I'm going to put Exhibit B to this motion, your motion to compel, up on the screen and zoom it in a little bit. And in part, was this the objection to one of your supplemental interrogatories?
Bentley, this is a trial within a trial within a trial. Yeah, this is
Correct.
This is very much what the rules of evidence are
Tell
designed
me
to
what
prevent,
your
and to the extent you're
interrogatory
supposed
was
to do this,
asking for in number
preliminary.
one, please.
Well, in its broader terms,
Well, let's just read it real quick if we could, please.
all
Can you
right,
read that?
list all checking and/or savings accounts, including credit union accounts, certificates of deposit, 401k accounts, SEP accounts, IRAs maintained by you individually and/or jointly with any others, or any other accounts over which you had signature authority in any capacity, regardless of whether or not the account or accounts have been closed.
Julia, I may
from
bail out
February
myself, ma'am.
2019 to present.
I may bail out
Ultimately,
myself.
what was
The decision to cover this was very, very last minute this
You don't have
morning.
to read that, but just tell me.
It was overly broad, unduly burdensome, and irrelevant.
And so ultimately, you filed a motion to compel, is that correct?
That's correct.
And the idea was, if you say you're broke, show me the books, and they had refused to with the response to this interrogatory, as well as others, is that correct?
Correct.
All right.
And this is really interesting as it relates. We are now, I just would like to take note about what exactly we're discussing at this point. Okay? We are now discussing a discovery dispute
To your knowledge, when
within the
information was
context
being
of the
gathered
civil
by the
boat
defendant
case.
in this particular case, let me ask you this, who were his attorneys in the boat case, Alex's attorneys?
So his personal attorney, as I've said,
Discovery
Henderson,
dispute.
who is also a partner.
Can I get
shareholder
access to the
with
bank
PNP.
account information?
Progressive had hired John Tiller, and John Tiller was a lawyer out of Charleston. He was mainly involved. At one point, there was Amy Bauer, who was an associate working with John Tiller, and then Elliot Condon ultimately. I think Amy left in February of 21, and by then I think Elliot Condon had been hired and was assisting John Tiller.
Okay. And Mr. Henderson is a partner in PMPED that was also actively helping Alec or representing Alec in this case, is that correct?
He was.
And he's the one that initially had brought you the insurance coverages for Alec to get you a chance to look at them and see what might be available, correct?
That's right.
I now like to go over those financials in detail. Turning to the bank account statement regarding the boat
As
lien.
this motion to
What
compel
is
gets
this line
filed,
85? Well, it says here
what
that
if
the
anything
boat
happened
has
with
been
the,
was
sort of
bought
the
for by
communications
purchase
between
money
your
security
side and the
agreement
defense side as we moved into the months
subject to
following,
to
filing of the motion
recapture.
to compel? We already
And
saw
what was the
what
monthly
else
payments on
is
that
going
account?
on.
Well,
$340.
there's a lot of
And did Alex
grumbling
make all those
and
payments? Well,
sort
one
of
month he
shock
was a
that
few days
I'm
late on
actually
making one, and
gonna
here's one
hold
where
Alec personally
3 days
responsible.
early.
Not
and
so much with
here's
me, but like
one
I
where-
mentioned, about a week
here's one
after
where the bank
this, Danny
got the check,
Henderson
but for some reason didn't
contacted
deposit
my
it for
partner.
5 days. And
There were a number of times when Tabor Vox was contacted. And so nobody says anything directly to me in terms of that regard, but that's what's going on. It was said to them.
where did
Alex
Alex Murdaugh got the boat? Well, as it turns out, he got the boat
When
from
we look at the
Savannah,
particular
Boats Are Us.
interrogatory right
And,
here that you
can you tell us the
filed a
entire
motion to
history of
compel on,
purchasing the boat? As a matter of fact, I
And
can.
what are you trying
Alex
to get?
Murdaugh was
What
interested in the
information
boat
are you trying to
back
get
in
with that
2017. And
Well, you know,
first of all, he went to Bass
the
Pro
way
Shop
to-
and he looked
again,
at this
like
kind of
I-
boat and then that
in my
kind of boat and then this
example
boat
of
and
the
that boat.
deal or no
Then he
deal,
decided he
I
needs
mean,
something custom
What I'm
made.
trying to do is put pressure. He doesn't
Okay,
want me
can you
to
tell us the
have
entire history of
access
how
to
the
his
boat was
accounts.
made? Sure, it
Time,
all
I think,
began with
because
an
he'll see-
entrepreneur's
I'll see
dream.
how much money he
He
actually
thought to
is
himself, you
making
know,
and how
I
much
would
he
like to go into
has.
the business of making boats.
And so, you know, that's what I'm
Let me
trying
tell
to
you,
do
it's
is
a
put pressure
whole
on
story
him
about how he struggled
to
in his
force
initial
him
rounds of
into a
financing.
settlement. You don't want it disclosed? Here are the keys to the jail. you enter into an agreement and let's go settle the case.
In the event, though, he doesn't settle in response to this, what information are you trying to get?
Well, it's certainly not a number. It's certainly not Alec's estimation of what his net value is. I wanted the accounts because I knew that the only way that he could be broke is that money had been hidden. And so I was going to look for and trace or begin that process of doing that.
All right, and explain that to the court. When you say that you knew that if he was, quote, broke, in your estimation, money had been hidden, and so therefore you were going to look for and trace that information. What do you mean by that? Why did you think money had been hidden?
Well, there wasn't any way he could be broke. I mean, I know he's actively settling cases. Some cases, big cases, some cases, small cases, but they stack up lots of cases. He's handling a lot of cases. So there's just no possibility that he could be broke by anyone's definition.
Well, no, by the rich aristocratic definition of, maybe I can cobble together $1 million.
Ultimately, and we'll talk more about this in a minute, if ultimately you'd been successful in getting a list of the defendant's accounts, what would have been your next step once received?
Subpoenas.
Of those accounts?
To those institutions, yes.
Thank you, Nicholas, for the super chat. I'd like to know where the
Were you
money
already
went.
aware that defendant had an account with the
Lots
Bank
and
of
lots of
America?
opiates, I guess.
I
Lots of
knew
opiates.
that he had a personal account with Bank of America. I knew he
Yeah.
had an account with Palmetto State Bank. So I'm looking for the balance of accounts in terms of institutions and where else he had.
But you didn't know how many accounts or what those balances were or anything like that?
No, I had no idea. I knew he had multiple business entities. He had different LLCs. So I imagine there could be any combination of accounts out there, and some which would not have even been in his name.
After the motion to compel is filed, I'm going to show you what's been marked as States 403 and see if you recognize that document.
Yes.
Tell me what that is.
Again, it's a screenshot of text messages between Tabor Vox and myself.
All right, put this up on the screen. All right, if you would, got this up on the screen, so can you tell me what's going on? And again, this is in April of 2021, is that correct?
It is.
And tell me what's going on with this conversation right here and how it relates to these issues.
Yeah, so in August of 20, I found out I had cancer. And by November, I knew how bad it was. And so in January, I went to, I had stage 4 cancer, and I went to Florida from the end of January till April the 15th on my first round of treatment. So I'd just come back. Shortly before I was diagnosed with cancer, John Tiller was also diagnosed with pancreatic cancer. And there's some degree of urgency between John Tiller and myself to finish this case. While I was in Florida, I think I failed
He's
to
talking
mention
about
that
himself? He had stage 4
Parker's Convenience
cancer?
Store was also a defendant in the first case, but Greg Parker had done a number of things. And so,
I mean, he looks pretty
so
good for a person who
before
has
I
stage 4
leave,
cancer. Damn.
the issue is Greg Parker's moved to transfer venue to Beaufort County, which is where I had done the mock jury. The focus group was in Beaufort County. And while I'm in Florida, things have changed in terms of what he's done that have changed my perspective, because when I left, I intended to go to Beaufort. By the time I get back, I think I'm staying in Hampton. And so this conversation is, for the first time I've said that I'm going to leave the case in Hampton, but if I think that Alec has fixed a jury, that he's done anything to affect the outcome of the trial, that I'm going to sue Paul and Maggie the next day in Beaufort.
And was that communicated to the defense?
Absolutely.
In the course of your investigation of this case, had you taken depositions of some of the officers who were involved in the investigation?
We did.
And at some point, was that some issues arose that were communicated to the state grand jury?
You're the one that tells me everything happens there is secret, so you tell me, but...
I'm asking you today.
But yes.
Ultimately, and while you were in Florida in March and April of 2021, to your understanding, had the state grand jury reached out to you for information that you had uncovered in your investigation of the investigation into the boat crash?
Correct. And specifically the handling of the criminal investigation by law enforcement.
The investigation into the investigation.
Correct.
Oh my God. The investigation into the investigation into the finances, into the discovery dispute, into the boat case. Does anyone remember when we were talking about a murder? Does anyone? Does it? Does anyone remember a murder?
I'm going to show you what's been marked as states 404, 405, and 406 to your, for this hearing, and see if you recognize those, please. Generally.
I do.
All right? And tell me what's going on here, please.
There were a number of motions pending in the boat crash case. They had been pending for some time. I mentioned one a moment ago, a motion to transfer venue. There were some motions to amend. And so Judge Hall had set those motions to be heard. My recollection is May the 10th, 2021. So I'm back now. I got a couple weeks to sort of get my wits about what's going on, and the motions are scheduled to be heard.
And that's May 11th, 2021?
It's either the 10th or my recollection is the 10th. I know the emails say something different, but, and in the week before, I don't know that John Tiller always knew how many chemotherapy treatments he was going to get or how long they were going to last until almost immediately before. So on or about May the 7th, John knew that the day of our hearing, his chemotherapy was going to run long and he wouldn't be done, and he had asked the judge to continue the motions, including the motion to compel.
All right. And looking at, again, we're now looking at states 405. What was the judge's initial response to Mr. Tiller's request to have that hearing continued based on his chemotherapy?
That we were going forward as scheduled, and that it says Mr. Condon, but it meant Miss Condon would be able to handle it.
All right, looking at states 406, what happened after that?
Ultimately, what happened is, my recollection is I sent another email to the judge expressing that I really didn't have, they were mainly my motions. Parker's had some motions, but that I didn't have a problem with continuing to accommodate Mr. Tiller. And the judge finally set a status conference for, maybe it was May the 11th.
All right.
When does James Charles enter the picture? That's what I want to know. At what point is James Charles going to enter this story? Because
Just said that initially Judge Hall did not want to continue the May 2021 hearing, saying that there was another lawyer for Alex's side that can handle it, correct?
Correct.
And then you kind of interceded and said that this would work, and so it was rescheduled. Is that correct?
After a status conference.
After
but
the status conference, it was rescheduled at that status conference?
It was rescheduled to June 10th.
June 10th? All right. I'm going to show you what's been marked as stage 407 and stage 408. And just quickly tell me if you generally recognize those documents.
I do. One is an email from John Tiller saying that the judge's law clerk said that the judge would be sending a message telling us that the hearing was going to be rescheduled to June 10th. The other is the email from the law clerk.
All right, so the hearing that was initially in May that Judge Hall did not want to reschedule was rescheduled for June 10th, 2021. Is that correct?
That is correct.
And ultimately, that would be to hear a number of things, but one of the most significant things would be your request for a list of all checking accounts from Alec, all identification of all accounts. Is that correct?
It is correct that that motion was going to be heard.
And ultimately, when the murders happened, I'm going to show you what's been marked as
Murders?
Exhibit 408. What happened to that?
The
particular hearing?
murders? We're going to talk about the murders now?
It was continued.
All right. And is that what's reflected in this email right here?
It is.
And then Exhibit 407?
It is.
After the murders happened, let me ask you this. You've known Alec and have worked with him for a number of cases, is that correct?
I had not worked with Alec in a number of cases, but I've known him for a long time.
Okay, but you were generally familiar with him as a lawyer, is that right?
I was.
And what was your assessment of his skills as a plaintiff lawyer? What was he particularly good at?
He was particularly good at reading people, making people feel like they were the most important person in the room, and capitalizing on surprise with the defense. You have a case with Alec, he hasn't done anything, it's Monday morning of the roster, maybe you expect it to be continued, and he says, I'm ready for trial. And so he leveraged a lot of settlements that way.
All right. Was he good at understanding the emotional and sympathetic aspects of plaintiff's work and tort work that can be so crucial in defining what recoveries can be in these types of cases?
Yeah, I think he was particularly good at
Wow,
reading
could that
people
question
and
have been any more
knowing
leading?
What made
I mean, I
people
know it's a
tick.
preliminary hearing and all, but damn, that might be the most leading question I've ever heard in my
You
life.
testified that you had
Be
made it very
particularly
clear to
good
the
at
defense
exactly
throughout
this
time
thing.
period
I want
that
this
you were
exact
seeking a
piece of
substantial
information.
personal recovery from Alec and had been told, well, he's broke, which you then responded, I don't believe that. Show me the books, correct?
Correct.
And that was what was on the table for June 10th, 2021, correct?
Among other things, but
Among
yes.
other things. But that's on the table, correct?
Correct.
After the murders happened, did that have any effect on your assessment of the case against Alec, and particularly as it relates to the sympathies and the emotion of the case, which can be so important to recovery?
Yes. It did.
Explain that to the court then.
Well, initially, probably say the first week, there was the shock and horror of what had happened. And nobody really thought about anything other than that. But pretty quickly, I recognized that the case against Alec, if he were a victim of some vigilante, would in fact be over.
Would be over.
It would be over.
And explain just quickly to the court why that's the case.
Well, when you're asking for a money judgment, people have to be motivated to give you that money judgment. If you represent Attila the Hun versus some sweet old grandmother, nobody's going to give Attila the Hun money. They would give money to some sweet grandmother. So if Alec had been victimized by a vigilante, nobody would have brought a verdict back against Alec. And I had other defendants in the case, so I would have ended the case against Alec.
You would have ended the case against Alec with just,
You know, I probably, I mean, certainly there was $500,000 in insurance that was offered. I may have tried to see if he could cobble together the $1 million, but whatever the last offer would have been from Alec's side, that would have been the offer that we took.
you had mentioned before that you had advised the defense of some of the mock jury presentations that you had done and some of the results from that and how they were very favorable to your case. Is that correct?
The defense and some of Alec's partners, yes.
And it's fair to say, though, that as you just stated, that if Alec had been the victim of some sort of vigilante, those sympathies would have entirely changed as it related to Alec and Paul as well. Is that correct?
Certainly.
And that's led to what your assessment then in the wake of these murders. Is that correct?
Correct.
At some point, did you receive any call or any communication from the Satterfields about any recovery in Gloria Satterfield death?
At some point, my recollection is it's early September of 21, Eric Harriet came to my office about that. There are a number of articles in the paper or the papers that are talking about this previous wrongful death case and wrongful death settlement, and he came to my office at that time.
All right. And did you send them to someone?
I sent him to Eric Bland.
Go on for 1 second.
A. Hettinger, did you miss something? Nope.
Nothing further this time, Your Honor.
Kill
By the
me.
defense.
Kill me. So James from court got chided for staring at the jury. Is that what I'm understanding from chat? Someone had a word with him for looking at the jury a little bit too much.
You
Is that what I'm
testified
understanding
at
from
length
chat?
to the state grand jury, basically this.
I don't know anything about this story.
Today, is that correct?
The testimony I gave today is included in what I said to the state grand jury, yes.
And it seems like the gist of this is that you were suing Alex Murdaugh, who you believed was underinsured for this incident, and you're going to go after his personal assets, and that was going to put some financial pressure on him. Is that correct?
Probably not exactly. I mean, I don't mean to quibble with you over the words you used, but I don't think it was financial pressure because I was holding him personally accountable. I was insistent that he pay. I didn't see how a payment plan on a settlement would put any pressure on Alec. It was sort of a deal that he couldn't turn down from where I sat.
But you were asking for money from
Oh,
him.
sure.
Yeah. And the inquiry here today is about money, his finances, correct?
I don't think so, but it certainly concerns his money.
And you're anticipating you're going to go to trial, is that correct?
Yes.
You're going to go to trial and get a verdict against Alex Murdaugh, correct? That was what you thought. That's where this was going.
No, I mean, I didn't see how any reasonable person wouldn't settle the case, especially Alec. So I expected the case to settle. 90% of cases settle, maybe 99. But if we had to try it, yes, we were going to try it.
And if he were unable to offer more money, then your expectation on, say, on June 7th, before these murders, your expectation was if he doesn't offer more money, we're going to trial.
Any money.
Right.
It was no money. No money had been offered.
So your expectation then was we're going to trial.
If you offer me no money in a case that I'm pursuing against you, then the response is we are going to trial.
And you were pretty far from trial on June 7th, 2021, were you not?
No.
You believe you were close to taking it to trial?
There was an urgency because John Tiller knew that he had about a year to live. And we were going to try that case. My expectation was early fall, late summer.
You expected to try the boat case in the summer of 2020, late summer of 2021?
August, September, October, sometime in that time.
You felt like you were only 2 or 3 months away from trial?
Sure.
Even though we had all these pending motions that hadn't even been heard, including what venue to have?
I had tried the case 2 times with a Beaufort jury during COVID. I was ready to go to trial.
On that day, on June 7th, you hadn't even yet asserted a negligent entrustment claim against Alex, had you?
Well, I had with John Tiller. John Tiller knew and had agreed to the amendment.
Right.
There were a number of things that Alex counsel had agreed to, including knowing that there was substantial punitive evidence in the case.
But you, at that time, you hadn't even asserted that claim to the court. That wasn't before the court, was it? That was just a conversation with John Tiller.
That's the conversation that mattered, because John Tiller would be the one who would object to the late presentation of the evidence, the late presentation of an expert, and he had agreed to all those things.
But he had objected to the financial discovery you asked for.
Well, there was an objection posed, correct?
But he did object to that.
When that answer was given in October or September of 20, it was an objection.
And the hearing that motion to compel the financial detail, the testimonies, that's just one of many motions that needed to be heard. Is that correct?
Correct.
There were many motions that had piled up and needed to be heard.
There were several.
There were several. Do you remember what they all were?
There was a motion to change venue. There was a motion to compel against Parker's. There was, Parker's had 1 or 2 motions. Some of the motions got resolved, one of which was this motion to assert admiralty in the case, and with the agreement that I would amend to assert your negligent entrustment claim, to get in all of the evidence that they knew I had. That was resolved that way.
And you've had a lot of motions practice in this case with Parker's, haven't you?
More so since the murder.
But has that motions practice with Parker's been about the murders of Maggie and Paul?
Well, I mean, it's about it in the sense that that it certainly created a lot of additional issues to deal with, but not specifically.
There was a lot of motion practice about allegations of leaking of video from mediation, for example, correct?
I don't know about a lot, but I had filed a motion that I ultimately withdrew.
And you believe that you were going to drag Parker's to a trial within 2 or 3 months, late summer of June 7th, even though we have all these fairly preliminary motions that haven't been heard, change of venue, asking to amend pleadings, motions to compel discovery.
Yeah, maybe you've never tried a civil case. So when COVID happened and everything was shut down for 2 months, I got my case together. My case is not dependent on, if I'm forced to try it, the bank institutions where he has accounts. My case is not dependent on the leaked video, that's a separate matter, and ended up being a separate lawsuit. So the answer is yes. I was ready to try my case.
And you didn't need, for example, an answer on the motion to compel that was pending against Parker's. You didn't actually need any of that stuff to go to trial against Parker's. Is that what you're saying?
You're talking about the percentage of financials, percentage of sales that alcohol made up in his profits? No, I didn't need that.
Well, let's put that up.
I wanted it, but I didn't need it.
Show you what's been marked as Defendant's Exhibit 82. You recognize that?
It appears to be my motion to compel against Greg Parker's company.
We pull up 82, please. And this is the document on the screen that I've handed to you. So we have, it's not just buried in here is some request for financial information, but you're requesting answers to request for production 3, request for production 11, request for production 16, request for production 17, which is financial information, request for production 18, request for production 19, request for production 20, request for production 22, request interrogatory number 5, interrogatory number 8, interrogatory number 9, interrogatory number 10, interrogatory number 12, interrogatory number 13, interrogatory number 15, interrogatory number 18. It seems like it's quite a bit of discovery you're demanding from Parker's in this motion.
Which I would have had the answer to on June 10th.
Why?
I wasn't getting it, but my case wasn't dependent on these things. They may have helped my case. They may have put pressure on Parker's camp like I was trying to put pressure on Alec, but the trial wasn't dependent on these things.
And turning to the motion to compel,
Nothing
Alex,
really matters.
first, do you believe that
Anyone can
the
see.
Judge Hall's initial
Nothing
request to
really
go forward in the
matters.
motion hearings
Nothing really
was
matters.
telegraphing a ruling on that specific motion, or do you believe that that was him looking at these motions piling up and wanting to get some movement?
Yeah, I think so. There's nobody in the courtroom, maybe even including me, that wants the case resolved more than Judge Hall.
And when the late Mr. Tiller asked for a continuance, you don't believe that was any kind of stalling tactic, do you?
No.
That was a legitimate health-based concern.
And if you read my emails, you would see that I immediately agreed to it. John Tiller was my friend.
With regards to what you're asking for from Alex, let's maybe pull that up. I believe the state has already marked this as an exhibit, but this is the motion to compel. Can we pull up 80, please? It's already been shown to you, but I'll show you when it's been marked as 80 for your reference. So this is asking for an order compelling production on interrogatories 9 and 10, and then a set of supplemental interrogatories and supplemental requests for production. Is that correct?
It is.
And if we turn to
And 9 and 10 are important as well. We didn't cover that, but I'm happy to speak to 9 and 10 because, 9 and 10 asked Alec about...
Sir, no one's asked you about it.
Okay.
And we'll get to it, but first let's turn to answers to first supplemental interrogatories. This is the first page of Exhibit B. So we can see what it is that is being asked for.
There's no D in mine, I'm sorry.
B.
Oh,
Exhibit
B?
B. It's the first page of what's Exhibit B in here. It's right there, that's it.
I think I figured it out. Dementors have escaped from Azkaban and are patrolling the streets in South Carolina. And the reason I know that is because when Dementors are out and about, one of the things that people will say is that it sucks all the happiness out of the world and makes you feel like you'll never be happy again. Yeah, great.
Sharing plans, pension plans, etc. Doesn't this look like supplemental discovery after you get a judgment? Supplemental proceedings?
I never had been involved in supplemental proceedings, so no, I don't think so. This is what my people needed answers to before they would agree to take anything that Alec would have offered.
In tort cases against individuals, in this case, a negligence in entrusting a boat and in an alcohol-related incident, before there's even motions for summary judgment, before there's any consideration of whether a case has been made for punitive damages, do you typically get this level of financial discovery of defendants?
I think so. I think the judge ultimately agreed to give it to me.
He agreed to give it to you?
Sure.
But I thought
What are Dementors?
Well, you thought wrong. There's a lot of papers, so maybe you got
They're the prison guards,
granted this
Azkaban,
motion?
I think so. You want to see the order?
and they suck all of the happiness out of the world.
It's the record, October 7th, 2021.
And correct me if I'm wrong, what you've highlighted here is that Mr. Tiller, because the circumstances beyond his control, unable to gather, provide necessary information, answer requested interrogatories. Once the information is made available to Attorney Tiller, the court will schedule a hearing.
If necessary. You forgot the last part.
If
Am
necessary,
I alluding
the
to a
court will
movie?
schedule a
It's in the
hearing
book.
If necessary.
Which
in the
means
book.
Mr. Tiller, the attorney on the case, can, from his own client, get the information. This is no way says that the court granted this motion, does it, sir?
only to you, I think. I mean, it's clear that John said that Alec was unavailable because he was in rehab at the time. He couldn't get the material. He's going to get the material, and the judge ordered, you get the material, and if we need to schedule a hearing because you don't have the answers that you want, Mr. Tinsley, then we'll reschedule the hearing.
I mean, this is an order that says the court will schedule a hearing on this motion to compel if necessary. It's not granting the motion to compel, sir, is it?
Cersei, in addition to her actions at the SEP, have taken over King's Landing via motions to compel. That's where Cersei went wrong. Too much blowing up. Not enough motions to compel. I'm going to start calling motions to compel Dracarys. Ugh. See, are these jokes working for anybody?
Well, I think so.
Which is October 6, 2021. You asked for financial information in the motion that was pending against Parker's that was also going to be heard on June 10th.
It was different and for different reasons.
This witness and this trial is more disappointing than season 8 of Game of Thrones.
Let me finish
No,
my-
no, sir, I'm asking what you asked for from Parker's. I'm pretty sure that wasn't, they say he's broke. What were you asking for from Parker's?
I asked for, among other things.
Winter is
the
coming.
of,
Winter is
alcohol sales
coming.
that Made up his.
It's coming any day, guys.
And this was like the dram shop action against Parker's, correct?
Oh my God.
Like a dram shop action, yes.
And did you get a ruling on that? That request for that financial information from Parker's that was going to be heard on that June 10th day, just along with all these other motions that had piled up in a case that apparently wasn't moving very
Well,
quickly.
I understand you don't want to acknowledge what I've handed you, but
I asked you what the ruling was on the motion, compel from Parker's.
it was very limited, and as it related to the percent of sales of alcohol that made up his profit, it was premature. The judge ruled, unlike he did in that order.
Are we seriously talking about percentage of alcohol sales because we're seriously talking about a dram shop action now? How did a dram shop action get into this?
And Alec is that Alec had, and his lawyers had 25 videos of alcohol. They had the punitive
You got
damages
what?
evidence. You didn't see that with Parker's. It was just a straight up transaction and sale. So to the extent you're suggesting that there wasn't this evidence, there were these mere allegations of negligent parenting, that wasn't the case. That wasn't the
You
argument.
presented that evidence to the court?
I didn't have to present it to the court. That's what you don't understand. John Tiller knew about it. John Tiller is the one who's responding because John Tiller knows ultimately he's going to be in front
So
of the
you're saying
judge.
the court was granting your motion, though obviously it was saying there might be a hearing on the motion, and maybe at that hearing you would present some evidence in support. But
I don't think that's what it says.
I mean, you asked for financial information from Parker's. It was deemed premature because it related to punitive damages, correct?
It was different than the motion that related to Alec.
Because the law is how much money you have is a factor for punitive damages, correct?
Well, you're making statements of law. I'm telling you what was happening, and what was happening is that Alec's lawyers knew what the evidence was, they knew what the amendment was going to be and the allegations, and he knew ultimately he was going to be back in front of Judge Hall making some ridiculous argument that appears you're suggesting now.
And again,
We are seriously
the gist of this
litigating
is
whether
that
or not.
there's
Okay, I just want to make this
perhaps gonna
clear
be
because
this
I can't even
judgment
believe
day. I
what's
think it's
happening right
determined.
now. We are seriously debating at this point whether or not the judge was going to grant some particularized motion in the boat case or not. We are now arguing about whether the judge would have granted some motion that was, I suppose, technically pending at this point, if I understand it. So it's technically pending. This guy is saying, I had an agreement with the other lawyer, so it would have been granted. And this lawyer is saying, but it hadn't been granted yet. And now we're having an argument over whether or not the judge would have granted it. Incidentally, for what it's worth, not that it really matters, incidentally, but it is possible for both lawyers to agree and the judge to say no. It is unusual, obviously, because most of the time, if the parties are happy, the judge is happy, but it is possible for both parties to be like, we agree, and the judge to be like, nah. Because the judge, of course, is the finder of law. And if what both parties want is not the law, then, it can happen. So they're kind of both right, I guess, in some sense. But I don't fucking care because it's not the murder.
Interested?
Not even remotely close.
Isn't that you don't, in your opinion, there's no case law out there saying that's what you get. That's the measure for punitive damages, net worth. There's no such case in your opinion.
I had 7 circuit court orders where the circuit court had ruled that you don't bifurcate discovery, that it wouldn't be proper to have denied the motion, and then what are we going to do? We're going to try the case, and suddenly we're going to stop the trial and go and do the discovery? No. And so I had 7 circuit court orders that I handed up to Judge Hall that supported our position. I think that that's what Judge Hall did in his order. And again, the issue is not that complicated. It's, does he have the ability to pay? Is he broke such that these people should accept this pitiful offer if he could cobble it
But
together.
sir, that's not what you get on a motion to compel, is it? Right, you just said ability to pay so your client can make a decision on whether to accept a settlement offer, but that is not what the motion to compel is about, is it? It's about evidence for trial.
The motion
That's
to
the legal
compel-
standard, is it not?
No, the motion to compel was about putting pressure on Alec. I didn't really get
What
two
the
cents
fuck are you
about whether or
talking
not,
about?
He ultimately had money, because I knew he had
All
money.
right, I'm gonna help
I
you
didn't
guys
need
out
those
real
things.
fast.
The fact that he didn't want me to
What
have
do you
them
think the
is the
purpose
reason
of
that
the
I'm
motion
pushing
to
it.
compel is?
So,
I just didn't know why he didn't want me to have them at the
To put
time. I
pressure
do now.
on
so
Alex.
the motion to compel.
What is the purpose
was
of
to
a
put
motion to
pressure
compel?
on Alex. It wasn't about an expectation the judge was actually going to give you this stuff on June 10th?
If you're a good plaintiff's lawyer, everything you do in a case is to put pressure on the other side.
But the expectation of the outcome of a hearing on June 10th was not that you're going to get to launch a full-scale forensic audit because you had a conversation with someone whose lawyer said, oh, he's broke, and you didn't believe it. Not at that stage of the litigation, sir, is it? That's not what's going to happen, is it?
I don't think you need a full-scale forensic audit for something a 5-year-old could see.
What the
so,
fuck
no.
are you talking about?
You wanted pretrial ability to pay discovery to inform whether or not to accept a compulsive discovery, compelled, so that your client could decide whether or not to take a settlement offer.
I know you don't like the answer, but I'm telling you, I did not care about the answer. What I cared about was putting pressure on Alec. I think that your assessment
you
of the law
didn't
is
care
wrong,
about the motion to
and I
compel.
didn't really care whether
You
I
filed
got
it-
it at
what
the
you're
end of the
telling
day. I
me-
knew he didn't want me to have it.
So
And so
wait a
that's
second,
what I
wait a
was doing, was
second, wait a
putting
second.
pressure on him.
At this
Would have
point,
suited me fine
you
not to have
seem
ever
to be
gotten anything
testifying
and
to
to leveraged
abusing
it
the
into
legal
a settlement
process,
and
sir.
gone on about my way.
Because
That's not
you're
what happened.
telling me you filed a motion to compel,
So
not because you
the
actually
motion
wanted
was
to
not
compel,
about
but because only because you
obtain,
wanted to put pressure on him.
information.
So technically, at
that may
this
have been
point, I
relevant
think you're testifying to misconduct under the
It
rules
was
of
about
ethics.
getting information to inform whether or not you want to.
You can only file motions
What I
for
told
their
Judge Hall
appropriate
was,
legal
they
purpose.
say he's broke.
So the purpose
My
of a
people
motion
have
to
lived in
compel
Hampton
is
their entire
to
lives.
compel.
I do not believe he's broke.
That's the purpose.
If he's broke,
It
we
might
need
have
to
other
open the books
things
and let them
beyond
see
that,
it
but
so
the
that they can
purpose
then form
is to
a
compel.
an
It's
informed
right in the name. That's why I was asking the question
opinion
the way I
about
was
what they
earlier.
should
Like,
do.
well, the purpose is to
It
put
didn't,
pressure
it
on.
didn't
I'll tell
have
you it's not.
anything to do with,
What do you think
with
the purpose of a
trial.
motion to compel
It
is?
had to do
It's
with
to compel.
the case,
Amazing,
resolving the
right?
case.
So what you're saying to me is, now,
And-
I didn't
and
actually
I think
care
briefly touched on
about the motion to
Satterfield.
compel.
Just
I didn't
because
really
they came to you
care
the first time they
about the
came into
judge's
your
answer.
office,
My
or
purpose
not,
in filing it
was
was to
September
put
21.
pressure on Alec.
It's
Which
it's
sounds
either late
suspiciously
August
like
or early
you're abusing
September.
legal process.
But very early September, and since
So-
now I'm thinking that since the roadside
Yeah.
shooting, whatever that ridiculousness was,
Also,
was the 4th, it could have been
what
August.
does it have to do with the murders?
But it was well after June 7th.
It was after June 7th.
Beg your, court's indulgence.
Aunt Mimi wants to know, how am I doing right now? Hopefully that answers your question.
If the hearing had gone forward on June 10th, this was a Thursday, what outcome did you expect?
The same one that we got when it went forward. The judge hadn't seen.
Well, I mean, the outcome wouldn't have been the court will schedule a hearing. I mean, if the hearing had gone forward, what outcome would you have expected?
Well, now I know that Alec was working on Monday to get the information together. If the objection was sufficient, there's no reason he would be getting the information together on Monday. So I could have gotten the information. But since that didn't happen, if we had argued it, I think I would have had the same outcome. Because he didn't.
Let me just make it a little simpler. would the court have issued an order, right? Some order would have issued on the motion.
Yeah, I would expect an order
And
to
just
issue.
break it down. An order would have issued at some point later, and what, if it were granting your motion, what would that order say?
I think it would say the same thing as,
Well, sir, that says a motion hearing will be scheduled if necessary. It obviously wouldn't say that. So what would the order granting
Well,
the motion say?
look, again, what it says is.
Are we
is that
seriously
once Mr.
asking
Tiller
about
gets
what
the
a
information
motion that
from
would have been
Ellen,
granted would have said?
gives it to me, if necessary.
As part of a
if I
discovery
deem it
dispute
insufficient,
relating to
then we'll have another
financials
hearing and we'll argue about it.
And a dram
So
shop
that's what I
action
Voluntary disclosure?
for Alex's
and then if you deem that
liability in
insufficient,
the
we go have
boat
a
shop
motion to compel
case?
hearing?
That's the way motions to compel
Is
go
that-
every single day.
Is that what we're
So-
doing now?
If you deemed it insufficient, if the court actually had to issue an order on your motion, what, you would have gotten you've gotten his, would the law firm books have been open to you?
I don't know that I'm asking for the law firm books. I'm asking for Alex.
Right. Would you
Accounts.
have gotten, what, a financial statement?
No.
The court would have ordered every account detailed listed to you, all his personal accounts? Just because you asked for it to inform a settlement decision?
I was asking for the names of the institutions where he had accounts. I've told you that a couple
Right,
times.
to subpoena.
Sure.
And,
But that's different
and
than
that would
him
have been
giving me.
resisted, and there would have been further litigation. This process would have taken some time, wouldn't it, if it was resisted, right?
I'm not sure if what was resisted.
If you got the names of the banks and issued subpoenas, there would be motions to quash the subpoenas.
Well, you're
Right.
speculating the same as you're asking me to speculate. I'm trying to talk to you about what the judge actually did and what was actually in front of the judge. I get you don't want to talk about that, but, and we can speculate any number of things could have happened.
That at some point in the future, you would maybe get a voluntary disclosure, and if you didn't like it, then the motion would be heard, the motion to compel. That's what you say it says, right?
Well, if we had shown up and they had made the argument that you're advancing here, then maybe in this imaginary world, there's things that didn't happen, the judge would have actually ruled on it. We would have a ruling on whether or not it was relevant, whether or not I was entitled to it.
And you'd have been relevant for Alex, but not for Parker's.
Look, there are different things that are being asked here. And to your point, if it were the same, why didn't the judge sign the same order that you say he would have done? That's not what he did. At the same time we argued the Parker's motion, we argued the motion for Alec. And so he came to two different conclusions on those issues. One is he said it's premature. The other is that Mr. Tiller's going to get the information, give it to the plaintiffs, and if it's not sufficient, we'll have another hearing. I don't know how you can be any clearer than that.
We are now arguing about if someone had objected and then this would have happened, and here's a thing as it relates to a discovery dispute in which is somehow a dram action, I guess, relating to Murdaugh's financials as it relates to the boat case, motion to compel. And are you taking cyanide pills? Did you bring cyanide pills? Did you bring enough to share?
So just, and maybe we can agree on this. The hearing had gone forward June 10th. That day would not have been some sort of judgment day when everything unravels, correct? There would have been further activity, maybe a voluntary disclosure, an analysis by you whether it's adequate, another hearing if you thought it wasn't, maybe some subpoenas would go out. There was going to be some time after that. Is that fair?
I think it's fair to say that there wouldn't have been an explosion on June the 10th, but the fuse was lit the moment that information became available in the case. Not as much to me, but certainly to Danny Henderson, who would have, like the phone records, like some of the other materials, reviewed it before I got it. And Alec would have known that.
I mean, in that analogy, aren't you really saying the fuse was lit when you were going after his assets, and that fuse was going to go down until trial because you're going to go to trial against him, and that's when the fuse would burn down?
I think the fuse was lit when he started stealing money. Yeah.
So it wasn't going to be lit on June 10th.
They're certainly getting a lot more oxygen.
Right, but
What the fuck is going on?
It's going to keep burning well after June 10th.
I don't know about well after, but it wouldn't have been Judgment Day on June the 10th, but he would have known it was beginning to unravel.
Not Judgment Day.
Banner?
No further questions.
Banner for what?
Yes, sir.
Banner for
That's
what?
really the point, isn't it, though, that had that hearing taken place on June 10th, 2021, it could potentially set in motion, or was going to set in motion, a process that ultimately would not have ended until there was either settlement or disclosure of that information, correct?
I believe so.
And so just the fact of that hearing taking place, and whether it's an order or representations by the defense or whatever it is, that process, if it occurs, starts and it has an inevitable conclusion, correct?
Objection, Your Honor.
There's only one.
Objection, Your Honor. Leading.
Don't lead the witness.
If the hearing takes place on June 10th, 2021, what is the net effect of what could happen at that point?
The discovery of everything he's done.
Whether it happens that day or some point in time.
Correct.
You had filed this motion to compel, or had you filed this motion to compel because you had been advised supposedly that Alec was broke and you didn't believe it?
Exclusively for that reason.
And you believed that if he was broke, he had to be hiding assets?
And if he were hiding assets, he didn't want me to discover it, which would be the pressure point.
Were you merely asking for a financial declaration at this June 10th, 21 hearing?
No, I was, it's broader than that, but I wanted the institutions because I knew I couldn't trust the number I would have gotten
From Alec?
from Alec.
You were asked a little bit about having not pled certain theories yet at this point in time, such as negligent entrustment. Can you explain a little bit about why that was, if that was still out there?
It was only out there in the sense of the pleadings that were on file. I mean, John Tiller had already agreed to the amendment. It was already coming. I had shown him the videos a long time before that of alcohol, the Facebook, social media likes of Paul consuming alcohol, having alcohol. So only on the documents that were filed.
Sir, were those issues, though, in play in your conversations with the defense?
I'm sorry?
Were those issues already in play in your conversations with the defense?
I'm not quite following you. Which issues?
Additional theories of liability that might not have been filed.
Oh, absolutely. No, I mean, those were, all I'm saying is that the black ink wasn't on the white paper, but John Tiller knew we had discussed these are the issues.
I cannot be bothered to care at all about any of this. Even a little bit. This is so tangential from anything.
I'm going to hand this back to you, but I'll show you what's been marked as States 407, so you can recognize that.
Yes, this is the order that I handed, whatever that lawyer's name was.
Mr. Barber?
Yes.
And that's from October of 2021, is that correct?
It is.
You had previously testified that $1 million, was not going to be enough, at least prior to the murders. Is that correct?
Correct.
Had you come up with a number that had been conveyed that was far, far in excess of that?
A demand to Alec?
Yes.
Yes.
And that also included signing over Moselle and Edisto,
It was an option.
as well as a payment plan?
Payment plan was an option. I mean, it was, you could pay this amount, you can sign over these properties, work out a payment plan on the balance. I didn't care how we got it done. It was just a matter of him doing it.
Was the payment plan an option because you believe that he still would have a lucrative law practice from which he could generate money to pay your clients?
Yes.
Thank you, Your Honor. Nothing further.
Anything further?
Nothing
All right.
Thank you.
Thank you, Your Honor.
Step down. Next witness.
No. Absolutely not. No.
Your Honor, a couple things. Our next witness would be Ronnie Crosby. Just to let the court know, the court indicated Friday that we had kind of already established, as far as clear and convincing evidence on the law firm issues. Mr. Crosby would be here about that meeting I referenced to, Your Honor, just to establish the circumstances of that. I don't plan at this time to get into testimony that he may offer about the circumstances of the fake forge and all of that, based on Your Honor saying that you had heard sufficient evidence regarding that. So I just wanted to make sure that was acceptable to the court. I did want to cross the bridge, though, of this meeting on June the 10th as to the circumstances of it. Again, and thus that if there was no attorney-client privilege to that because of the presence of third parties, then at that time, we don't have to do it on the stand, but I would, make myself and prep in the evening or whatever, privy to that particular conversation.
Any other comment about the attorney-client privilege issue, Mr. Griffin?
Your Honor, I'm still at a loss as to what he's attempting to accomplish through this.
He wants to call
Right.
some of the folks as witnesses who were there when you were there, along with Mr. Murdaugh.
And so it is the question, these witnesses are going to testify as to what Alec and I were talking about, because we've had attorney-client privilege conversations every day in this courtroom, and there are 250 people in this room. Does that mean that the conversations are not privileged? I don't think so. And so it really is more nuanced than is someone else in the room. And I don't know if they overheard anything that I talked to Mr. Murdaugh about, and that's where this is going, or if the question is Mr. Murdaugh talking to Mr. Crosby, and is that privilege? Or Mr. Murdaugh talking to Mr. Lee Koch, and is that privilege? I'm at a loss here.
I don't know either, but I say, as far as the law is concerned, that Mr. Griffin was not the lawyer for Mr. Crosby or any other party. Mr. Griffin was solely the lawyer for Mr. Murdaugh. So there is no attorney-client privilege involving people that Mr. Griffin does not represent.
Sure, and I guess what I'm actually trying out of an abundance of caution to protect his attorney-client privilege. I mean, Mr. Griffin says he's at a loss when I've been bending over backwards to make sure I'm not privy to something that Your Honor might find productive.
I don't know what you're seeking. There is no attorney-client privilege involving people that Mr. Griffin does not represent. If you have them as witnesses and you want to call them as witnesses, if there are necessary witnesses to this hearing, you may proceed.
All right, thank you, Your Honor. We would call Ronnie Crosby to the stand.
I don't know what the fuck is going on, guys. If you're about to ask me what are they talking about, I don't know what the fuck they're talking about. I don't know what happened. I don't know who's supposed to be there. I don't know what they're testifying to. I don't know who overheard what. And assuming we get past all the privilege issues, if it matters, I will eat my hat, because at this point, nothing matters. So that's my working bet. We're going to go through this incredibly long slog about attorney-client privilege. We're going to find out the privilege does not apply, and then we're going to find out none of it matters. That is That's my prediction. Because it's the way that this entire story is unfolding.
Okay? That is fine.
Okay. We're going to be disappointed, right? This is supposed to be the big reveal. This is supposed to be that Matlock moment, right? And what did he say? Your Honor, Alex Murdaugh said,
Left hand on the Bible. You
aren't the
affirm
leaves
that
pretty at Moselle?
trial shall be the truth, so help you God.
Shocking!
Thank you. Take a seat in the witness
Shocking!
stand. State your name again for the record. Spell your last name.
All right, who the hell are you? I'll put your name on screen for the fuck it matters.
Ronnie Crosby, Crosby, C-R-O-S-B-Y.
Mr. Crosby, how are you?
I'm okay.
All right. Tell the court what your profession is and where you work.
I am an attorney that practicing law with the Parker Law Group.
And are you a former law partner of the defendant, Alex Murdaugh?
I am.
You see him in the courtroom here?
I do.
And where is he sitting?
He is sitting between Mr. Griffin and Mr. Harpootlian at the defense table.
And again, this is an in-camera hearing, so you understand I'm not exploring everything that might, depending on the judge's ruling, be before a jury. But I do want to explore a particular meeting. Were you present for a meeting in which the defendant spoke on June 10th, 2021?
I was.
And at this particular meeting, can you tell the court who all was present?
I'm not going to swear that I don't miss somebody because it was a fluid event. My recollection is it would have been late morning, midday that we gathered at Alec's brother John Marvin's place, which is not very far from Alameda that y'all been talking about. And I know I'd been by to see Mr. Randolph that morning. There was going to be a meeting with law enforcement. They had given Alec a couple of days before they were meeting with him, and so we gathered there. I was present, Mark Ball was present, Lee Cope was present, John Marvin was present. At some point, I believe, I don't remember exactly when Buster arrived. Jim Griffin arrived at some point. And I want to say Corey Fleming was there. And there could have been others.
All right. While that group of people were assembled, did the defendant, and I don't want to get into the content, but did the defendant make any statements about what had happened on the night of June 7th, 2021?
He did. We were there as friends. We had been with him starting the night of the murders every day, and we were there for support, and he went over the events of that afternoon, or that evening, starting from the time he got home from work until the discovery of Paul and Maggie.
Where was this discussion taking place? Was it inside, outside?
We were in John's house there. I guess, I don't know if he calls it a house or a hunting lodge, but we were inside. But largely, I mean, there was some in and out of the house as well, but the majority, we were all sitting in a room together, and I was doing more listening than talking.
And were these the statements being made by the defendant? Were they being made quietly to his counsel, or were they being made openly to all the people in the room?
Well, the statements that I heard obviously were being, for me to hear them, I was not overhearing a conversation that was private between Mr. Griffin and Mr. Murdaugh. They did have some private conversations that the rest of us were not privy to, but so there's a mixture of that.
But there were private conversations that you don't know what they were because you weren't privy to those, correct?
Correct, and this was before, I believe, the South Carolina Law Enforcement Division agents arrived at this location.
To be clear for the court, you did at other times, aside from this meeting or this discussion, have conversations with Alec about his activities the night of June 7th, 2021. They were outside of this, is that correct?
Well, that's correct. I mean, obviously, we all were in shock, but also wanted to try to find out what all had went on, because we,
Thank you for the super chat, Comer. That's
you
very
know,
kind of
as
you.
we got past that night of June 7th and the morning of June 8th, we're all, you know, trying to help find out what had happened and you know, who may have been a potential suspect.
But in this investigation and in preparation, you were instructed to stay away from those until from that meeting, as opposed to the other ones that weren't in that meeting, out of an abundance of caution until we could get guidance from the court as to whether or not those in any way were protected. Is that correct?
That's correct. I mean, we had multiple conversations, as you might expect, all of us in a group, and it may be pieces and parts, but what you and I have discussed up until now have been outside of what was discussed on June 10th at John Marvin's house.
Okay. Your Honor, I don't believe I have anything further for purposes of this matter.
What the fuck just happened?
Anything further?
Please, court. Crosby, I believe Danny Henderson was also there.
Yeah, I told you I might miss one, but Danny was there. I don't think Danny was there at first, but he ultimately arrived.
And the meeting had been scheduled so that Alec and others, Brother Randy, for one, and John Marvin and Buster, could be interviewed by SLED. Is that correct?
That's correct. The purpose was to, that SLED had scheduled a time, and I don't know who scheduled it with, and you're correct, Randy was there. And it was essentially going over the timeline of the evening of the 7th, because knowing that that Alec was going to be interviewed, and I think Buster was, and maybe Randy and John Marvin over the course of that afternoon.
And you were not scheduled to be interviewed, correct?
I was not scheduled to be interviewed, and Jim, now that you speak of it, I do think that while Mr. Randolph did not come into the meeting, he and whoever brought him over did come by. Right. There are two that I'd forgotten.
Yeah, and
then went back to Alameda,
where he died within hours of that, right?
He died as we were leaving, or right after we left this meeting with law enforcement. We were on our way back to, and Randy got a call.
Did you sit in any of the interviews conducted by SLED in the car?
I did not.
Okay. And Lee Cope was there, and he was not to be interviewed, right? That's not why he was present.
We were there as friends to provide support and listen.
And Mark Ball also was present?
Mark was, and I know Mark had some meetings with law enforcement about some concerns that he had, not about potential suspects and safety of.
And had you recall whether you and or Mark and Lee had given Alec some advice about whether he needed to have a lawyer at this interview?
I don't remember that specifically, but knowing that you were already involved, I mean, any of us would have thought it was a good idea.
Okay. Do you know whether Alec considered you and Mark and Lee, as well as Danny and Corey, as his counsel that day? I mean, do you know what he was thinking?
I don't know what he was thinking, but he never approached me as his lawyer, or throughout this, I never had the perception that I was representing him.
Well, did you, or in your presence, Mark Ball or Lee Cope, make it clear to Alec that, hey, we're not your lawyers here, and if you talk to Jim Griffin in my presence, then there goes the attorney-client privilege. Did you give him that warning?
Mr. Griffin, we're all lawyers. Other than John and Buster that were there, I don't think anybody needed to say that, and it never crossed my mind that when we were sitting in a room and all of us were talking that we were somehow representing Alec.
No, I understand that. And it was, okay.
And nor would I ever do that because I don't practice in the area that you do.
Right. But it's clear that Danny had an ongoing attorney-client relationship with Alec, is that right?
He did with regard to the boating accident. He was Alec's personal counsel in that.
And Danny had sat in the initial interview in the that was conducted by Sledge Agent Owen and Collin County Deputy Laura Rutland on the night of June the 7th. Are you aware of that?
Yes, I was aware of that.
Okay. And he was representing Alec during that interview, as far as you know.
I don't know. I saw, I mean, I know when Alec got in the car, we felt like one of us ought to sit in there with him, you know, for support because.
Well, can you say for certain that whenever you heard conversations from Alec about his recollection of what happened on the 7th, that there were any non-lawyers in the room? And I guess non-lawyers have been Buster and John Marvin. I mean, can you say for certain there were no non-lawyers in the room?
There were.
That you're referring to hearing conversations with Alec in the group about what happened on the evening, the events of the evening of June the 7th. And my question to you is, when Alec was making these statements, let me make it clear, were there just lawyers in the room?
I can tell you that John and Buster were there for points of time. Can I tell you who was sitting and where John had walked out? When I heard any specific thing, I can't tell you that. I couldn't catalog because I said it's a little bit fluid. People come and go, and you know, law enforcement arriving outside and people walking out to greet them. I mean, it wasn't like the sled agents just showed up and it was, you know, some rigid thing where you walked out. I mean, there was small talk going on with the officers as well.
Sure. Okay. 1 second, Your Honor, please.
Let's see what's coming up in the Supreme Court this month. Nothing to... Ooh, Gonzalez versus Google on the 21st. That'll be a good one. Section 230. Dealing with 230 liability. That'll be a big one on the 21st.
That's all the questions I have.
We'll probably do a Supreme Court react to that. What is this one on the 22nd? Twitter versus Tamath. What is this?
This issue.
This particular issue, no, I
No,
know that's a little bit different than the larger issue we've been.
New York versus New
dealing with.
Jersey?
I'd certainly be happy to argue that further.
What is New York suing New Jersey over for now?
As far as the larger issues, one of the things that we, in
Dealing
discussions
with
the
the
defense,
ports,
we stay away from so far in
mutual
testimony
access
is the
to
side of
ports.
the road. And that might be the
Dublin
piece of
versus the United
puzzle,
States on the
that
27th.
Might need some in-camera testimony as I think all of this through. I know that we're butting up with the jury being here shortly.
You've been dealing with arbitration.
Yes, sir.
Anything further on this issue regarding evidence of other crimes?
Aside from the side of the road, not at this time, no, Your Honor.
Do you have other witnesses to present on any other issue at this time?
No, sir, other than I had a summary witness for the side of the road, but, that would be it. As
Biden
for
versus
in-camera
Nebraska? What's
proceedings
this
before Your
about?
Honor, to get a handle on all of the.
Oh, this Department of Education Student Debt Relief Plan, whether the states have standing. That could be fun.
No, that would be it. That's from that side of the road.
We're going to take a break of about 5 minutes, and I will announce my decision regarding this other evidence.
Okay, so we're going to get a decision on this other evidence stuff. All right, we'll stay for that. All right, so coming up at the Supreme Court on the 21st is this case Gonzalez versus Google. We've done some coverage on this already. This is dealing with 230A. It's not the major one, or it's not the one that you're most familiar with. This is dealing with whether or not YouTube, because it was YouTube, right? I think it was whether or not YouTube, maybe it was Google. Either way, it was one of them. It is one of the alphabet companies. Whether or not they can be held liable for the algorithms which promote content as opposed to the content itself. So under B, they can't be held liable for the content that other people post. But there's a question as to whether or not they can be held liable for the algorithms that promote content. And so the Supreme Court's hearing that on the 21st. That'll be an interesting argument. And then there's something dealing with Twitter, whether a defendant that provides generic, widely available services to all of its users and regularly works to detect and prevent terrorism. I don't want to hear from you, whoever you are. I don't care. Regularly works to detect and prevent terrorists from using those services knowingly. Provides substantial assistance under 18 U.S.C. 2333 merely because it allegedly could have taken more meaningful or aggressive action to prevent such use. And what a defendant whose generic, widely available services were not used in connection with a specific act of international terrorism that injured the plaintiff may be liable for aiding and abetting. I would think aiding and abetting would require more. 18 U.S.C. 2333. Any national of the United States injured in his or her person, property, or business by reason of act of international terrorism, or his or her estate, survivors, or heirs may sue therefore in any appropriate district court of the United States, and shall recover threefold damages he or she sustains and the cost of the suit, including the attorney's fees. So you can just sue in any district court. So we're trying to sue Twitter. We're trying to sue Twitter for knowingly providing substantial assistance to terrorists. Feels like the answer to that probably should be no. But that could be interesting, I suppose. If the answer to that question were yes, then presumably it would impact just internet providers generally, email providers, everyone. Interesting. Sort of. So I would think it would require more than just generically providing services. But I suppose they'll turn on the statute. Did you miss anything important? Well, the judge is going to rule on this other acts evidence after a lot of hearing on the issue. So we're going to that. Ron White gives $10. Thank you very much. Yeah. So, okay. So I'm not so sure about that liability. Coinbase versus Belisky. Whether a non-frivolous appeal of denial of a motion to compel arbitration oust a district court jurisdiction to proceed with litigation pending appeal. I'm not sure. Does appeal deny, appeal take up, prevent the court from hearing further issues? Okay. Interesting stuff. The immediate problem isn't in defining terrorist, because this is relating to acts of international terrorism, which is defined in 2331. The term international terrorism means activities that involve violent acts or acts dangerous to human life that are in violation of the criminal laws of the United States or of any state, or that would be a criminal violation if committed within the jurisdiction of the United States or any state, that appear to be intended to intimidate or coerce a civilian population, to influence the policy of the government by intimidation or coercion, or to affect the conduct of government by mass destruction, assassination, or kidnapping, and occur primarily outside the territorial jurisdiction of the United States or transcend national boundaries in terms of the means by which they're accomplished, the persons they intend to intimidate or coerce, or the locale in which the perpetrators operate or seek asylum. So that's how we're defining international terrorism. I hope that answers your question. And then the question, more the point, is whether or not, the question is not, did the people do the international terrorism? That's not the question. The question is Twitter liable for aiding and abetting the terrorism by providing a generic platform by which people can communicate? And I would think the answer to that question would have to be no. But yeah. Fucci is pleading guilty. Sentencing might be a while. Different courts do it different ways. Some courts sentence pretty fast. Some courts do it pretty slow. So it's going to be up to the individual court. But last second settlement, not exactly unheard of. I think whatever the judge's answer is going to be is probably wider than it should be. I think the best answer probably here, maybe the boat case stuff, but even that I'm a little bit dubious on, to be honest. I just think the tie is thin. But I think the judge is probably going to let a lot more of it in than I'm comfortable with. I get that feeling. Maybe I'm just reading the tea leaves wrong, but I think the judge is going to let a lot more in than I'm comfortable with. And our odds of appealing a eventual conviction are going up. But we'll see. We'll see how that all pans out. I think when the judge reaches his determination as to I don't see any reason actually to wait. I'm going to go bounce over with Nick Ricada now. I'll go watch this over there. And we'll discuss a little bit more this morning over there, I think. Forgot to monetize the stream. Lol. I'm going to go, let's see, customization, redirect over that way, save that. All right, I'm going to go redirect over there and discuss some of this stuff with Nick for a little while and hang out with him. And I probably won't do an afternoon stream. I'm betting right now because it just seems so pointless and so meaningless. But we'll see. I'm going to go hang out with Nick and try to gain some energy over there. So I'll see you guys over that way. You should automatically be redirected. So I'll see you over there in a bit. Say hi to everyone. I'll talk to you guys later. Bye for now.